everyone. Welcome. My name is Deirdre Baker. I am one of the attorneys with the Makovsky Law Group. Thank you for joining us today. If you attended any of our previous webinars, welcome back. And if you're here for the first time today, welcome for the first time. Our previous webinars covered topics including surrogate financial and medical decision-making, as well as paying for long-term care. If you were unable to attend any of those webinars, please feel free to visit our website or contact the office, and we'd be happy to guide you in getting a copy of that recording. Today, for the last installment of this webinar series, Lisa Valente, one of the partners at the Makovsky Law Group, will be covering how to leave assets to your heirs at your passing. Before I turn it over to Lisa, I just wanted to let you know or point out that there is both a Q&A and a chat function at the bottom of your screen. So during the presentation, if you have any questions, please don't hesitate to put them in the Q&A or chat boxes, and I'll be monitoring them and we'll be addressing questions at the end. So without further ado, I'm going to turn it over to Lisa, and I hope everyone enjoys.
Thank you, Deidre. Thanks for that great introduction, and welcome everyone today. So today we're going to be talking about how to leave assets, and I'm just going to try to switch my slide here. Hold on. How to leave assets to our loved ones at death, which is something we deal a lot with here in our firm, and we address. So we're going to get into it. So how do we leave assets to our loved ones at death? So there are a few different ways we can leave assets to others at death. But it's important to first note that we are here in New York State and that the laws governing how assets are passed, the inheritance laws, are very state specific. And everything we're going to be talking about today is related to New York State law. New York State law is going to govern the topics we're talking about today. So there are four basic categories of how we can leave assets to others at death. Assets can be inherited by what's called operation of law, and we're going to be talking about all of these in just a short bit. So we have assets that pass by operation of law. We have assets that are inherited by intestacy. We have assets that are inherited by last will and testament. And we have assets that are inherited by trust. So we're going to dive into each one of these a little bit so we can distinguish one from the other. So I'm starting off with how assets pass by operation of law. And the reason why I'm starting with this first is because I find that these are the types of assets that clients are most familiar with. These are assets that have a designated beneficiary or a joint owner on the asset, and they will pass automatically to the named beneficiary or surviving joint owner at death. And when I say joint owner, I'm talking about a joint owner with right of survivorship. So some examples are life insurance policies. Typically, your life insurance agent has you fill out a beneficiary designation form when you purchase a policy. The beneficiary of your policy will inherit those monies automatically at death after presenting a death certificate. Retirement accounts are typically assets that pass by operation of law. Again, they pass to the named beneficiaries. In transfer accounts and transfer on death accounts, those are accounts, typically bank or investment accounts, that you've already designated who is to receive that asset at death. And then we have assets that are owned jointly with right of survivorship. We often see this between couples on the title to their homes. Their house could be owned jointly or even their joint bank accounts. So these are assets that pass by operation of law and simply require the presentation of a death certificate, and they become the designated beneficiary's asset. Then we have assets, and I'm going to go back just one second, I'm sorry. Assets that pass by operation of law, I want to highlight that it's important to note these assets that pass in this way typically supersede any directions that you have in your will or in a trust. So I wanted to highlight that before I moved on to the next slide. Then we have assets that pass by intestacy. So intestacy means that the person has died without a last will and testament, and they have assets that require, they have assets that need to be administered by their estate. And there is no will and no designated executor in a will to administer the estate. So when this happens, New York State has a statute that sets out who will inherit and in what proportion. In addition, the court, a court, and typically it's the surrogate's court in New York, will appoint a court administrator. A court administrator is similar in function to an executor named in a will, but again, we don't have a will in this case, so the court is going to appoint an administrator, a court-appointed administrator. And the administrator and the beneficiaries, it's really important to know that if you die without a will and you have assets that are going to pass through your estate, the court's going to appoint the administrator. The law is going to say who the beneficiaries are of your estate. And oftentimes, this may not be who you would want it. It may not reflect your wishes. So this is not an ideal circumstance. Then we have assets that pass by last will and testament. This is a document that many folks are familiar with, but it's important to understand what actually passes by last will and testament. Assets that pass by last will and testament are assets that have no direction where to go and become part of the deceased person's estate. And so often we hear, we call this the person's probate estate. They're assets that we need the named executor in the will to gain control of, to collect, to marshal, and then to distribute to the named beneficiaries in the person's last will and testament. So in a will, this is where you can name who you want as the executor, who to be in charge of your estate, administering your estate, and ultimately distributing the assets of your estate. In your will, you can also name other fiduciaries, such as a trustee. You can set out the plan for distribution of assets at death in your will. You can include tax planning provisions in your will. And speaking of tax planning, we're not going to deep dive into that today in this webinar, but I am going to point out that when we talk about taxes, it's important to know that a decedent's taxable estate typically comprises all of these different types of assets that I'm talking about today. So when I said earlier, assets that are jointly owned with someone or have a beneficiary and pass by operation of law, they're still going to be part of the taxable estate. And assets that pass by will, such as what we're talking about right now, the probate estate, they're still going to be part of the taxable estate. So that's a different issue, but I wanted to point that out. In your will, you can make special provisions for trusts for certain special individuals. So you can create trusts within your will. Some examples would be there's a disabled beneficiary that you want to leave money to, but you don't want it to affect that disabled person's government benefits they're receiving. Another example would be you want to create a trust within your will for minors. In the event a minor may inherit under the will, we want their share to be held in a trust for them with someone in charge of the money for the minor. So these are things that can be accomplished within your will. It's important to highlight that signing a valid last will and testament in New York requires the person signing the will to follow the statutory requirements that New York state law has set out. They're very particular, so there's a formality to it in order for your will to be deemed valid. So when we're talking about your will and your probate assets, which are the assets that are going to pass via your last will and testament, let's talk about what probate is, because I often hear from clients, I don't understand what probate means. So again, it's state specific. In New York, probate is not typically this horrible process that a lot of my clients walk into the office thinking. However, there are circumstances, and we're going to get into them in a little bit, when you may want to think about trying to avoid probate. But let's start with what is probate. So probate is the judicial process of submitting a decedent's last will and testament after their death to the local surrogate's court to have it reviewed and scrutinized by the local surrogate and deemed a valid last will and testament, at which time the local surrogate, the judge, officially appoints the nominated executor in your will to be the executor. So it's a court proceeding. It's a process that requires certain notice to certain individuals. And it's important to know that your named executor in your will does not immediately have authority to act as executor right at death, because your executor has to go through this probate process, go to court to have the will deemed valid before he or she can receive their official court paper saying that they're the executor. Only at that time, then they can begin administering the estate. So this process is different in every state. We often hear about clients with, property in Florida, and they say, well, how's probate in Florida, California? Florida and California's probate system is quite different than New York's and requires, it's a little bit more complicated and requires more work, I should say, and there could be more time involved in their processes. So it's just important to know that if you have property in other states where their probate process is a little bit more complicated, it's something to think about if you want that to happen. So I'm going to turn to now another way we leave assets to others at death. We leave assets to others at death sometimes through a trust. So what is a trust? A trust is a legal agreement where you have the creator of the trust setting out some terms and some goals that the creator of the trust wants to accomplish. The trust typically could provide for management of the trust assets during life and also provide for the distribution of trust assets at death or some other prearranged date. So there are lots of trusts, different types of trusts out there, and clients often get confused because they're not sure what trust is right for them or if they even need a trust. So let's just start with some basics. There are two different broad category types of trusts. We have testamentary trusts, and then we can have living inter vivos trusts. A testamentary trust is a trust that is created under one's last will and testament. So as I said earlier, you can in your will set up a trust at your death for a special beneficiary, perhaps a disabled beneficiary or a minor. That trust is only created at the time that your will is submitted for probate, and that is said to be a testamentary trust because it's created under your will, under the terms of your will. Then we have trusts that are called living trusts. And these are trusts that are created during your life. They're created and become effective during life. And typically, we can have revocable trusts or irrevocable trusts when it comes to living trusts. And we're going to get a little bit more into these types of trusts, or we're going to get into a revocable type of trust. This is one that we often use when we're talking about how to leave assets to others at death. So we're going to use a revocable trust as our example to explain a little further today. So a revocable trust is a trust that is, again, created during your life. The creator of the trust can amend or change the terms of the trust at any time. This is often used to provide for management of assets, the trust assets during life, and it will provide for distribution of assets often at death, or again, it could be some other prearranged time. Typically, there's no special tax advantage to creating a revocable trust, but what it's really known for is it can avoid probate. So as I said earlier, probate is the process of submitting your will through court, having your executor appointed to have the authority to administer your estate. We're going to go over some of the reasons why someone may want to avoid that process. And when we do want to avoid that process, a revocable trust is a good vehicle for doing that. So just some basics about a trust. Who are we talking about in a trust? So the creator of the trust is also known as a settlor or grantor. And then the creator of the trust names a trustee. And the trustee is the person who is going to manage the trust assets. This is who the creator has designated to be the manager of the trust assets and to follow the terms of the trust. And then we have the beneficiary of the trust. And this is who, again, the creator of the trust designates as the person who's to benefit from the trust assets. And that could be trust income or trust principal, but that's the person who's meant to benefit from the trust assets. And sometimes these different players could be the same person, or they don't have to be. But those are the basic parties we're dealing with when we're talking about a trust. Really important to know about a trust. One really important thing to know about when you're creating a trust is that the trust has to be funded in order for it to control the assets that it was meant to control. Meaning a trust is only going to control the assets that the trust owns. So if the house is to be part of the trust and to follow the terms and directions within the trust, that will require, perhaps if the house is, has a deed, retitling the deed of the house to the trust. Bank accounts or investment accounts, same concept. If you want the terms of the trust to control those assets, the assets need to be retitled. The trust can only control what it owns. So that's important to know because we have seen clients come to us thinking they had a trust, new clients come to us thinking they had a trust and that it held certain assets, and upon further investigation, the assets were not properly entitled to the trust. So it's important to know that the trust has to be funded with assets for it to control those assets. So when would we consider irrevocable trust over a last will and testament. This is a good option if you are concerned about providing for money management during your lifetime. You're a single person, and you're concerned as you age that you may not be able to handle and manage your finances as you continue to age, and you want to leave some mechanism in place for a smooth transition of management. This would be a good consideration. Another time irrevocable trust is a good idea is if you own real property in more than one state. So we often see our New York clients with their second homes in Florida. And, we explain to them that if they die, their probate of their will happen, their primary probate will take place in New York. And however, when you do probate in New York, remember it's state specific. New York will only control the assets within New York. And the New York court cannot grant the executor authority to manage, sell, distribute the property, let's say, for example, in Florida. So it will require the executor to then file another probate, what's known as an ancillary probate proceeding, in that other state. And again, when you're filing a probate in a different state, you're following that state's laws, which may be different than New York laws as far as timing and complexity. So a revocable trust is a good idea when we have these clients with properties in more than one state and they don't want their family, their executor, to be going through all this trouble to gain control of these, assets, especially in another state. And what we would do is then create a trust and put the properties into the trust. Another reason you would want to consider a trust and trying to avoid probate is if you're concerned about there being a will contest. Someone, is estranged from the family. When you file probate in New York, certain relatives are required to receive notice of the probate proceeding, and there are certain relatives are required to receive a copy of your will. And the court will not name your executor, will not officially grant your executor full authority to move forward with your estate until the court has obtained jurisdiction over all necessary parties. If there is a concern that some family member who may be entitled to notice may contest the will, this would be a very good option for avoiding that. And to kind of piggyback off of that, let me explain. When you have a trust that is controlling the distribution of the assets of the trust, and there are no probate assets that have to go through the will, then you don't have to go to court at all. The beauty of a trust is that it's an agreement you created during your life, and it doesn't require a judge to deem it valid. Unlike a will, it doesn't require a court proceeding or court involvement. So if you're thinking that someone might be contesting the will, someone might contest the will, or there may be missing, distant, or unknown heirs that by law are required to receive notice, and now we can't even find these folks, and it's going to hold up the will and hold up the probate process. Irrevocable trust is a good idea, is something to consider. Another reason to consider a trust is to preserve privacy of family and financial affairs. When you file your will after death with court and go through the probate process, the records at the local courthouse become public records. And there are some families who don't want the terms of their wills exposed to the public, or that anyone can go to the courthouse and look up what is going on in the probate proceeding and what provisions were in the person's last will and testament. So a revocable trust is a good option if we are looking to preserve privacy. And it's a really good option if you are just concerned about providing a smoother and more seamless transition of assets at death. If the plan works as it should and we avoid probate, your children, I often hear, I want to make it as easy for my kids as possible. Your children don't have to go to court, wait 6, 8, 12 weeks at best for a judge to deem a will valid and then grant the authority. This provides for an immediate, smoother, seamless transition of assets because, again, the trust doesn't have to go to court. You've already put the players in place, who's to step in, who's to take over, and it works much smoother that way. So this list are the typical circumstances that we see when clients really think a revocable trust may be suitable for them. So that recaps, that summarizes the basic categories of how to leave your assets to others at death. Deidre, if there are any questions, I'd be happy to answer them.
Yes, there are some questions here. So one question is, does a revocable trust protect assets from creditors without lien or such on assets in the trust? So I guess, does a revocable trust offer any creditor protections?
Typically, revocable trusts do not offer protection against creditors. There are other types of trusts that can do that, but they come with different strings attached to those other types of trusts. But the trust that I used as an example today, no, typically does not provide creditor protection.
Okay, there's a few more questions here. One question is, my father printed a will off a template he found online. Is that okay?
Well, that's kind of vague, but it depends. So I said earlier in the program, it's okay if it is signed, if it's signed in accordance with the requirements set out by New York state law for it to be a valid last will and testament. So the fact that it was printed off online doesn't mean it's not okay. It's how it is signed. And the law requires, there's a whole bunch of things it requires. So you just have to conform with the requirements set out by law.
Okay. Another question here asks, can I put my 401k in a trust?
So typically, we don't recommend that retirement assets be retitled to a trust because there are different tax consequences to a trust owning retirement assets rather than an individual, or a trust inheriting retirement assets rather than an individual. So it's not typically a great idea, but that's something, upon further examination, we always advise on.
Okay. I have another question here that asks, all of my assets are jointly titled with my spouse. Do I need a will?
So I hear that often. I started the program with assets that have beneficiaries on accounts, that are jointly owned, on life insurance. And often I hear clients say, well, I have beneficiaries and everything, and I own everything jointly with my husband. So I don't really need a will. That's not true, because even when you own assets jointly, husband and wife, when the first passes away, the second spouse, the surviving spouse, will inherit, but then they don't have someone to leave it to. So what typically couples will do are have wills that mirror one another, because we don't know who's going to go first, but they're set out to act on the second one's death. And another thing I want to mention, and I should have mentioned this earlier, another reason why you want to consider having a last will and testament or some other document in place is, again, I have clients that say, well, I have assets with beneficiaries on everything, so I don't need a will. They're going to pass, by operation of law. Well, there are some circumstances you still need a will. First of all, if you have minor children, you can only name the guardian for your minor children in your last will and testament. So that's really important. Secondly, we don't know if someone might die, let's say, in a car accident, and your family wants to start a wrongful death lawsuit. You need an executor for your estate appointed to have the authority to start a lawsuit. So even though we hope that doesn't happen, it could happen. So it's always a good idea, even if you have beneficiaries or joint owners on everything, to still have at least a will as a backup.
Okay. A couple of these questions you've answered already. So another question that just came in is, can I make changes to my trust or will documents?
So you can make changes to your will. I'll address each one individually. So when you create a last will and testament, as long as you have what's called testamentary capacity, enough capacity to make any changes to your will while you're still alive, you certainly can do that. And you can revoke your prior wills, and you could do that as many times as you want, as long as you have capacity. But when you die, your will is set in stone. Your last will and testament is your last will and testament, and that's it. And then it speaks at death what you want. With a trust, depending on what type of trust, but I spoke a lot about a revocable trust. Typically, same thing, you can make changes, you can amend that trust as much as you like, as long as you have, again, capacity to do so. And with a trust, you can also grant someone under a power of attorney authority to make changes of your trust if needed. But yes, changes can be made as long as you have the capacity to do so.
Okay. And then I think we just have time for one more here. And the question is, I have a US savings bond that is transfer on death to my child. Does that also pass under operation of law?
Yes, a savings bond that has TOD, transfer on death, to a designated individual, as long as that designated individual is still alive when you die, they can go and collect that savings bond by operation of law, meaning they don't have to show your will or anything, just a death certificate to prove your death, and they should be able to collect that.
Alrighty, so our contact information is on the screen. If you have questions that you didn't ask or you want addressed in more detail, please feel free to contact the office. Again, I want to remind everyone, if you were unable to attend our previous webinars, you can find the links to them on our website, or again, contact the office. I hope everyone learned something today, and thanks again, Lisa, for the presentation.
Yep, thank you everyone for joining us today.
Bye, everyone, take care.
Have a good day. Bye-bye.